Of this NDP Liberal government, Canada has entered uncharted territory. This government has made Canada a candy store for car thieves, and under their watch, organized crime has made Canada a key exporter of deadly fentanyl. Canadians and now the whole world know that this Prime Minister is not worth the cost. This NDP Liberal government must take responsibility for this failure, which has brought crime, chaos, and corruption not only to Canadian streets, but the streets of the whole world. Perhaps is there a Liberal Party leadership candidate who can rise and tell us who's been running this place for the past 9 years so we can hold them to account.
Hey gang, what's up? Just Aaron right here, Question Period Canada. Do you recognize Dane Lloyd from the introduction there? He's a wild MP, another cowboy from Alberta, giddy up, St. Albert, Alberta. And he has some stories to share, guys. The government is irresponsible. The Supreme Court is letting us down. These are some very interesting pieces I believe Canadians need to see. Doesn't sound good the way that it's being taken care of right now, but it's good that Poilievre has studs in his army like this cowboy Dane Lloyd taking care of Canadian business. Let's check out these videos. They're frightening, guys.
The Supreme Court, in a decision by one vote, has now made Canada the safest place in the world to be a child predator. In a groundbreaking 5-4 decision, the court has now ruled that Canada's police forces require judicial authorization to get an IP address, a warrant to get an IP address. What this has done is essentially halted all investigations into online child exploitation.
We're seeing an immediate impact already where telecoms providers have already denied us information about the IP address.
According to my sources, nearly every child predator case in this country that involves IP addresses has been shut down in the wake of this decision. It's unacceptable. Let's take a step back. Why did the Supreme Court make this decision? It's all about privacy, Section 8 of the Charter of Rights and Freedoms, and a principle called the reasonable expectation of privacy. Now, prior to this decision, it was the rule of the land that you did not have a reasonable expectation of privacy in relation to your IP address. Imagine for a second that there's a hit and run, and the police have access to the license plate. The Supreme Court of Canada is essentially saying, in relation to IP addresses, that they're not allowed to look up that license plate and get the name of the person who potentially did the hit and run. It's ridiculous. You do not have the right to privacy on the internet when you're committing crimes against children. This isn't some hypothetical legal ruling that just happened. This is having real-world consequences today. We have RCMP members who are publicly speaking out, talking about how the judiciary and the telecommunications companies and the ISP providers are already denying them the critical information that they need to crack down on these child predators. This Liberal government is totally asleep at the switch. I even went and asked the Minister of Public Safety at committee if he was tracking this issue. He's not even aware that this is happening. Minister, there was a pretty groundbreaking decision earlier this month of the Supreme Court, the Bajavitz decision. I wonder if you can tell us about what the impact of that decision has been in the last month.
So again, I'm not familiar with the precise details of the decision. Happy to answer Mr. Lloyd's question, but the Associate Deputy Minister would be the best one to give you the precise answer to your question.
This decision has had an immediate effect on basically freezing and, in the words of some RCMP officers, terminating child predator investigations in Canada. And some believe that Canada has now become the safest place in the world to be a child predator. I wonder if you can give your comments on that, Minister.
Well, that obviously would not be a circumstance that's at all acceptable.
This decision came out earlier this month, around the same time that they launched their so-called online harms bill. This online harms bill does nothing to address the fact that child predators in this country are now protected from having their IP addresses accessed by police. Now, you might not be a conservative person, but you don't need to take my word for it. The dissenting judges in the Supreme Court, the 4 dissenting judges, even agreed that this will make it more difficult to prosecute cases against children. But in the end, I don't care what the lawyers and the judges are saying about this. What I care about is protecting Canadian children. And parliamentarians have a duty to override this flawed decision so that we can protect children from child predators. And that's why I believe we need to seriously look into invoking the notwithstanding clause so that Parliament can bring forward emergency legislation to override this flawed law and protect Canadian children. It's time to make Canada the least safe place to be a child predator.
Okay, if that video wasn't scary enough, let's take a look at his follow-up video to that one. It's so interesting, guys. I kind of like Dane Lloyd too. Giddy up. Check him out.
A video where I sounded the alarm on a recent Supreme Court case decision that has made it infinitely harder for law enforcement to investigate and prosecute child predators. After I published my video, I saw a lot of comments from concerned Canadians about privacy rights, about the police state, and about warrantless searches. That's not what we're talking about here. This is about a Supreme Court case that has taken away an essential tool that's been used by police for many years to investigate and catch child predators. And now the Supreme Court decision, which wasn't even dealing with a case related to child pornography, has really made it so much more difficult for law enforcement to do this very important work. We are losing the battle against online child sex abuse. Since 2014, the number of cases in Canada have tripled. So I think we need to delve into this case a little bit more deeply because the stakes are really high. What is an IP address? An IP address is a 9-digit number that's assigned to a computer when it accesses the internet. It's much like a license plate on a vehicle. Police who are investigating child pornography can see that there's an IP address, this 9-digit number that's involved, but they don't know who that IP address is related to. It's the next step where police have always been required to get a warrant to figure out who is possibly involved with that IP address. The FBI sent an IP address to the Canadian authorities. The Canadian Integrated Child Exploitation Units across our country take that IP address, they go on an open source website, which anyone can do. They type in that IP address and they tell you that there's a telecom company that services that. They then get a warrant to go to those companies and say, tell us who is associated with those accounts. When they get that warrant and they find out who's involved, then they have to follow up with more warrants so that they can actually investigate that person's house and possibly find any of the materials that they claim are in the possession of that suspect. Now, what the Supreme Court has done, they've now said that when the FBI gives that IP address to the Canadian authorities, that it's really inadmissible because they didn't have a warrant to receive that IP address in the first place. Now, some of you might be asking, well, why isn't the RCMP just doing these investigations themselves? Why do they need to get all of this intelligence from the FBI? Well, the RCMP can't just go down to the United States and investigate these cases, because then it raises the question about how they even knew to make this investigation in the first place. It's essentially asking the RCMP to look for a needle in a haystack, except the haystack is made of all needles. It's impossible. And even if they did find that needle in the haystack, it would be inadmissible in court because of the manner in which they received that information in the first place. It's shutting down investigations into child exploitation all across our country.
The head of Alberta's Internet Child Exploitation Unit says this ruling will make its investigations much harder. He says getting IP addresses is often the first step in finding online predators.
We're seeing an immediate impact already where telecoms providers have already denied us information about the IP address.
Now, I'm just as concerned about privacy as the next person in Canada. We don't want the government investigating our private conversations with friends and families. We don't want the government trying to find out what our political leanings are or what our personal opinions are or our religions. But what the Supreme Court is really envisioning here is a situation or a problem that really doesn't exist in Canada. Not only is it not a problem, the RCMP don't even have the capacity, nor should they have the capacity, to surveil every IP address in Canada. Now, would you care to guess how many RCMP officers are dedicated to this very important task? Is it 1,000? Is it 100? Well, in the province of Alberta, it's less than 10. One of those people are tasked with writing these warrants. Now, in the case of a 7-page warrant, it might take 4 hours to write it. But in the case of a 70 to 100-page warrant, which is often what's required in these complex cases, it could take weeks to write these warrants. And so it's not that police don't want to write warrants. It's absolutely essential to what they do. If they don't have the IP addresses in the first place, they can't even do the investigation. It's not a question of manpower. It's basically shutting down child exploitation cases as judges interpret the Supreme Court as saying that any information that's received about IP addresses, say from the FBI, is now inadmissible. It's like if the FBI saw somebody committing a hit and run with a yellow sedan, and that yellow sedan went up into Canada. And the FBI said, hey, Canadian government, there's a yellow sedan that was associated with a hit and run in the United States. Can you please check it out? Well, the Supreme Court's essentially saying that that information is now inadmissible. Police will still need a warrant in order to connect whoever's involved with these IP addresses related to child predators. They're still going to need a warrant to search their property and find the evidence that they need to prosecute the case. But what the Supreme Court case has done is basically shut down these investigations before they could even begin.
We're attacking this at global scale. This is the problem on the online side, is that, you could have a child in Winnipeg being victimized online and the offender is sitting over somewhere in the Netherlands. The servers where this stuff ends up being stored to be in the United States.
We can't accept this in this country. It's getting to the point where there's so much red tape that we're becoming a safe haven, not only for child predators, but for killers, auto thieves, and all sorts of other crimes. We have to make Canada a safe place for Canadians again. So where do we go from here? The courts have made their decision. Now it's time for politicians in Parliament to make their decision. Are we going to stand up for the rights of children and stand up to ensure that Canada is not a top destination for child predators? That means bringing in emergency legislation so that we can clarify that an IP address, which is less public than the license plate on your vehicle, should not be protected under privacy laws. This is an essential tool so that our police can get the ball rolling on these investigations. When they get a tip from our international allies, from the FBI, that an IP address is associated with child predator activity, they need to be able to take that information to get a warrant so they can find out who's involved. But the fact is that under the decision that this Supreme Court has made, if Parliament does not act, they will never be able to begin those investigations in the first place. And Canada will continue to be a top 5 destination in the world for hosting child predators. This is a big deal, and Parliament needs to act quickly to get it right. We had a lot of comments on our first video, and I encourage you to comment on this video. Let's have a discussion. Let's have a conversation about this critically important issue. As always, thank you for watching.
So what do we think here, guys? Are things out of control? Is the Supreme Court letting us down? Is it because of Trudeau and his current NDP Liberal coalition government? That seems very corrupt. We certainly want an election. 70% of Canadians say that in the polls. Whether we get one or not, I guess we'll have to wait and see. My name's Aaron, this is Question Period Canada. We have a great time. We watch all the live broadcasts of the Question Periods together. Come check out one of the live shows. It's a fun chat room. Pretty sure you'll enjoy it. That's it. It's a beautiful day here in Nova Scotia. We're going to go and try to enjoy some of the beautiful spring weather we have here. Canada's Ocean Playground. Come join us, guys. Aaron, Question Period Canada. Catch you next video. Thank you for watching this one. Have something healthy to eat today. And try to stay warm out there. It's getting easier to do. It is spring. All right, catch you next video.